In this video, we're going to talk about trial in the criminal defense context. Now, if you're accused of a crime, everyone knows that you have a constitutional right to have an impartial third party, whether that be a judge or a jury, hear your case and hold the state to its burden. Basically, to hear the case and decide whether they've met their burden and you are guilty or not guilty. Now, what people don't know is there are various different processes within the trial context that must take place. The first thing that's going to happen whenever a person is set for trial on the day of trial is the judge is going to come in and give basically a greeting to everyone and kind of tell people a little bit about how the process goes and explain to them why they're there and how long they're going to be there. This usually is pretty quick, and then the judge will jump right into voir dire. Voir dire or voir dire, depending on how you want to say it, is the process of jury selection or jury deselection. This is where the lawyers, both the state and the criminal defense lawyer, will get to ask the panel or the people that have been called for jury duty that day questions and help determine whether they have inherent biases or if they're going to not be fair in your trial. Now, this process, depending on the type of case, how much publicity the case has had, and the person in which is charged with the crime, can take a few hours or it can take a few days. And what the ultimate goal of jury selection is to make sure that you get a fair and impartial jury to hear your case. Now, after this is concluded, the judge will have the state begin with opening statements. You have to remember, throughout the entire context of the criminal defense trial, the state will always go first. They'll go first in jury selection, they'll go first in opening statements, they'll go first whenever they present evidence. Everything will happen with the state going first. And it's designed that way because it is the state's burden to prove that a person is guilty. So after we've done jury selection, the state will go first on opening statements, then your criminal defense lawyer will be able to produce their opening statement, and then the state will go right into presenting evidence. Now, evidence in a criminal defense case can range very widely. It can be very short with just a relatively simple matter to just having one officer testify, all the way up to multiple witnesses testifying, experts, police officers, and a whole host of evidence presented. The defendant has a small disadvantage here because all the state's evidence is presented first, and people tend to form an opinion before the defendant has even had a chance to present their evidence. But after the state's evidence is concluded, they will rest their case. And usually, this is a time when the defendant or the defense lawyer will make a motion for an acquittal to the judge. And if there's any sort of defect in the state's case, then the judge can grant the motion for acquittal. Now, after the state has presented their evidence, then the defendant gets a chance. The defendant gets a chance to present any evidence that is relevant to their case, including having the person testify if they want to, but there is no obligation for a person to testify in a criminal defense case. This would be a time for you to call an expert if you have an expert, or present any evidence through a private investigator that you've obtained. Remember that in any criminal defense case, that the defense part is generally going to be a lot smaller than the state's part because they are going to have the burden of proof. The defendant does not have to prove that he didn't commit the crime. The state has to prove that he did commit the crime beyond any reasonable doubt. So after the state has presented their evidence, then the defendant has presented his evidence. The last part of the trial will be closing arguments. Now, at closing arguments, it's your time to tell your story through your lawyer. Your lawyer is going to get a chance to get up and speak and point out the inconsistencies in the state's case and point out your theme of your case and how the state has not met their burden of proof. After closing arguments, then the judge will instruct the jury. He will read the instructions that have been agreed upon by the judge and both lawyers, and then the jury will be released to deliberate on the case. This will conclude the trial portion of your case. If you have any other questions about criminal defense or want something else explained to you in the criminal defense context, please view our website, rothdavies.com, for more information.